What's it matter? You want me to tell you? I'm going to tell you why. You've got a bad attitude. You can't get along with anybody. You've gone through 3 of our...
All right, pause right here. This isn't just a judge being mean. This is frustration boiling over. When a defendant burns through multiple court-appointed attorneys, the court starts seeing a pattern. And trust me, judges keep score on behavior.
Court-appointed attorneys. Ma'am, you asked, I'm telling you. So I'm going to give you a court date. It's going to be when? February? We got a clear agreement on this one?
I'm just asking for a withdrawal.
Okay. Ms. Frazier. Good. Mr. Jadala wants to withdraw. Any objections? That means he's not going to represent you.
And this is a huge moment. When a judge allows an attorney to withdraw, the safety net disappears. No lawyer means no buffer. Every word from here on out is on the defendant. Would you ever represent yourself in court?
At this point, nobody's going to represent you unless you hire somebody, because you've been through at least 3 of ours, and you can't seem to get along with people. So, okay. Okay, he's just asked me to withdraw. I've let him. So he's done. He's done with this case. He's done with this case. Okay. So the question is, do you want an adjournment so you can hire an attorney, or you just want to talk to the prosecutor and do it on your own?
Notice the confusion here. The defendant keeps jumping between issues. Evidence, lawyers, prosecutors. Courts run on structure, not emotion. And when someone can't stay focused, it works against them fast.
I need to talk to her. She got evidence that she didn't reply to you guys. So yeah, I need to talk to her.
Okay. Okay. Go out and talk to the prosecutor. I'm dismissing McKinney.
I apologize, sir. There's nothing getting problems with the prosecutor. She'll have to be advised of her rights.
Okay.
Yes.
So, Ms. Frazier, here's the question. Ms. Frazier, here's the question. Do you want me to adjourn the pretrial so you can hire your own attorney, or do you want to just... Pardon me?
On my own, because it's evidence that y'all.
Okay. All right. I don't have any evidence.
She has to come in.
All right. So you want to represent yourself. All right. So let's set it for trial. Do you understand?
This question matters more than people realize. Jury trial or bench trial can change everything. Who decides your fate, how evidence lands, even how lenient things feel. Most defendants don't grasp this until it's too late.
And the difference between a jury trial and a bench trial.
So you like the thing.
Pardon?
Leeway.
Okay. Okay. Is there a question there for me? I'm sorry. What's the question?
Hire leeway to run the thing.
You mean, can you hire one of our attorneys that are in here?
Leeway.
I don't know if you can hire them or not. I don't deal with legal aid.
Okay.
You can hire anybody you want to. I'm not.
Yes, sir.
Yeah. So, all right. So you want me to give you another date so you can hire an attorney? All right. I can give you a February date. It gives you all the month of January to get somebody lined up.
I'm not going to leave you drop off.
Okay, but I'm not going to make somebody talk to you.
Maybe let's speak to the prosecutor for that.
So, can I have a February pretrial date?
With Judge Parker.
Judge, she wants to speak back to Sammer. I don't know if that's a good idea.
Oh, that's no.
I think
You never tell me going to drop.
Let me ask you this. What does it matter? He asked me if he could withdraw. Obviously, he doesn't want to represent you.
Right here is a power shift. The judge is done negotiating, done explaining. Once a judge says, what's it matter? That's courtroom language for, we're moving on without you.
I said yes, so he's off the case. What's it matter? You want me to tell you? I'm going to tell you why. You've got a bad attitude. You can't get along with anybody. You've gone through 3 of our court-appointed attorneys. Ma'am, you asked, I'm telling you. So I'm going to give you a court date. It's going to be when? February? Ma'am, do not talk.
February 12th.
February 12th, what time? 9 a.m. Have a seat. We'll give you a paper notice, and then you're going to leave my building without talking to anybody. Are you clear on that? Ma'am? You're going to take your notice and you're going to leave my building. Ma'am, I'm talking to you. I'm talking to you. Do you understand that? We're going to give you a notice and you're going to leave the building without talking to anybody else. No, you're going to sit down right there and I'm going to give you a notice and then you're going to leave my building. You're not going to stop and collect $200. No, you're going to leave my building. Any paperwork you want, you can get online. You're going to sit there and you're going to be quiet and you're going to get your notice and you're going to leave. Anything other than that, I'll hold you in contempt.
And this is the final warning. Contempt isn't a threat, it's a tool. One more interruption, and this hearing turns into handcuffs. Drop a comment. Was the judge fair here, or did this spiral out of control?